Good evening. Welcome to the City of Fort Lauderdale Board of Adjustment virtual meeting of October 14th, 2020. Let me introduce Shaquila, you want to do a roll call? Let's see if we have a quorum, then I'll do the introductions.
I think. One second. We have
Bridget? Yeah.
Bridget, yeah.
You want me to do it,
Please.
Shaquila? Okay,
Yes.
sure. Eugenia Ellis,
Present.
Carrie Villeneuve,
Here.
thank you. Patrick McTeague,
Here.
Blaise McGinley,
Present.
Chadwick Maxey,
Here.
alternate Chip Falkinger, Shelley Eichner, alternate,
Here.
Mike Lambrecht, alternate,
Present.
thank you. And Douglas Reynolds
Here.
and Chair Howard Nelson.
Here,
Thank you.
and I
We
believe
do
we
have a quorum.
have a quorum. Alternates, you're obviously free to stay. But if you want to log off, we do have a quorum, and we've only got one item tonight, so we'll probably keep the quorum through that one item, I would imagine, I would hope. As I said, my name is Howard Nelson. I'm the chair of the Board of Adjustment. With me, I have Mr. Patrick McTeague, our vice chair, Blaise, and board members Blaise McGinley, Carrie Villeneuve, Chadwick Maxey, Eugenia Ellis, Doug Reynolds, and I believe that is it. And alternates Mike Lambrecht and Shelley Eichner. I also have, on behalf of the city, the board liaison, Mr. Bert Ford is the acting zoning administrator, Assistant City Attorney Dwayne Spence, our administrative assistant, Shaquila Crawford Williams, and our recording secretary, Bridget Chiappetta. We have Mr. Undetermined as our host and technical assistants. Thank you for the spelling of his name, Shaquila, helping us with this. That's okay. I was able to, I didn't know his first name was but that's okay. Who will, number one, keep track of those who've raised their hands to speak, and two, will ensure that the meeting is appropriately recorded. Our public speakers coordinator for tonight is Shaquila Crawford Williams. She'll keep track of any emails and calls and create a queue of public speakers, as well as she will advise me of any queue before the end of a public comment period. So, having a quorum, could we get we only have one item up tonight, which is item PLN 2009-0001, Michael Anthony Dutzer and Robert William Manseman.
Here.
Swore in. Yes, sir.
At this time, may I just announce that item number 2 will be pulled off the agenda due to defective notice.
Got it. So that again brings us to a one-item agenda. We may actually even still see daylight at the end of this.
Mr. Chair?
Yes, sir.
Approval of the minutes for last meeting. Do you want to review
I
them?
was actually going to do that a little bit later, but we can do approval of the minutes. Do I have a motion?
So moved.
Is there a second?
Second.
There's a motion and a second. No additions, deletions, or alignments from the minutes. All in favor of approval of the minutes? Aye.
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 Any opposed? Could you please show unanimous approval? All right, why don't we call the first item, 2009-0001, presented by Ryan Abrams, attorney for the applicant. Bridget, can you swear in anyone who will be speaking on this matter?
Yes. Do you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Yes.
Thank you.
Okay. Do you want me, Mr. Chairman, do you want me to take the floor and speak?
Please, before you
Why don't we-
present,
Yes,
I was just going to say, please state your name and your address. Okay, for the record.
Mr. Chair?
Yeah, we
Yes,
have
ma'am.
exclusions.
Oh, disclosures.
we haven't gotten there yet. So let's go through for disclosures. Miss Ellis,
Site visit.
Mr. McTeague,
None.
Mr. McGinley,
None?
Mr. Maxey,
None.
Mr. Reynolds,
None.
Mr. Villeneuve,
None.
and I also have none.
All right, and just to clarify, I think Chairwoman Ellis, I'm sorry, the member Ellis stated that she had visited the site.
Yes, sir.
Oh, okay, just wanted to be clear on that. Okay, so good evening to the chair, members of the board. Thank you for giving this matter your attention this evening. I am a land use attorney here in Fort Lauderdale. I represent the applicant, Michael Dutzer. We are here tonight on our application for a variance from the strict interpretation and application of the code to a privacy panel that the owner has built on the side of his house. This is a pretty limited project that he undertook with the sole purpose of ensuring privacy and an adequate buffer from the sidewalk going adjacent to his corner property and the street outside it as well. He was struggling with privacy issues on a number of levels. I have a presentation that I'll go through tonight, a PowerPoint presentation where I'll go through some of the photographs and I'll discuss some of the evidence that we have to present, as this is a quasi judicial hearing, and I am aware of our evidentiary burden, but we do intend to show that we meet all of the variance requirements, specifically that this is a unique special condition because of a high-risk flood zone, a higher than typical elevation, and a perimeter fence on the boundary line causing the backyard to be entirely exposed to public view. And the property owner taking steps to, in the most narrow way possible, ensure his privacy like any other property in this neighborhood is entitled to, and is able to meet those privacy requirements with current code requirements. Unfortunately, the property owner here cannot. So with that said, I'd like to appeal to the moderator to put our PowerPoint up. Hopefully that could be done without too much trouble. Okay, great. All right, nothing too, this won't be too long, but let's just go to the third slide to start out. Thank you very much. You want to do the full screen option? Would that be all right?
No, why don't we leave it here just so the board members can actually still be seen during the deliberations.
Good point. Okay. So the property address is 1725 Northeast 18th Street. It's a corner home. It was recently built. It's a recently built home in 2019. It is it's in a neighborhood off of like nearby Sunrise and US 1. Like I said, it's a corner property. There's a street that goes on both sides of it. It is in an FEMA flood zone, so it's considered high risk under the city's code, specifically section 47, chapter 47, subsection 2. There is a requirement that it be built at a 5 feet above sea level grade, or 18 inches above the lowest structure. So let's go to the fourth slide. So as a result of the FEMA requirements and the grade requirements. The finished floor elevation for this property is 6.5 feet. And the result basically is that the interior of the bedroom can be seen from the street. It's about 1 feet 7 inches higher than the sidewalk. So the perimeter fence is at the height limit of 6 feet 6 inches. So there's essentially the fence is basically 1 foot 7 inches shorter in its screening effect because of the fact that the property sits higher. We've actually provided a site exhibit ahead of time to the board. I don't know if you all have been provided copies of that. Have you?
Is it in the application package?
No, it was submitted last week via email to Shaquille. I don't know if she had a chance to provide that to the board.
Yes, Mauricio, can you please bring that up, please?
I received it via email.
Great.
That's a one today.
Am I able to do share screen? I can just share it on mine if that works.
Mauricio, does he
Sure,
have?
go ahead. You can go ahead and share screen.
Oh, I can? Okay. Apologize for the delay. Can everybody see my screen? Okay, so this is just a demonstration of what we're talking about from the back, from the patio. There's like a pool back there.
Yeah, hold on 1 second. You're a little frozen. There you go.
Sure. Okay. So this is just to demonstrate what we're talking about. There's like a pool patio area in the backyard. The owner has put a substantial amount of money into renovating the landscaping, redoing this entire backyard and the landscaping around the property, and it's really immaculate. And it's just he wasn't able to really enjoy it without having some privacy. So hence the reason for this privacy panel, which is actually very nice design. But this is what it accomplishes. It just gives them privacy, nothing too complicated. So I just wanted to show this to the board. And we can go back to the presentation. The moderator is able to do that. Do I need to stop sharing? Okay. All right, if we can go to the 5th slide. Okay, and this is just a visual on how it looks now. You can see that, from the master bedroom, it's got complete protection. That's how the pool area looks. It's pretty stellar, actually. You'll hear testimony that the neighbors have given nothing but high praise for it, and they've asked the owners. There have been requests for tours of the backyard. No complaints at all from neighbors that the owner has received. We can go to the 6th slide. This is to show the utility boxes that are right outside the privacy panel. This is one of the reasons that this became an issue, because like on a weekly basis, one of these are an AT&T box. I think it's the one in the middle on the left, bottom left. It's like an AT&T utility box. So on a weekly basis, you'll hear testimony that there's service workers that come out there and they're servicing the unit, and they're just able to look into the property. It's a real invasion for the owner. So that's something that he has no control over. So if we can go to the 7th slide. Okay, and there's just more visuals here, what we're looking at, and we can go to the 8th slide. This is how it looks from the outside. It's a unique design. It's intended to function as an architectural feature that goes above the fence. So actually in the code, it does provide for 18 inches above the fence height for architectural features. That was something that they thought they could meet, and that the city would consider this an architectural feature, but the city determined that they don't consider it an architectural feature above the fence, so they declined to consider it that way. But we think it's clearly a positive design. If we can go to the 10th slide. And just going through the criteria, we understand there are 5 different criteria that we have to meet. We think we can demonstrate that there are special conditions that affect the property at issue, which prevent the reasonable use of the property. The reasonable use of the property is obviously being able to use and enjoy the backyard like every other property in this neighborhood. The fact that this one has utility boxes next to it, that it's a corner property, that it's on a higher grade, these are conditions that make it unique, stand out, different than any other similar, any other property in the neighborhood or in this area or this zoning district. Right. Circumstances causing the special conditions peculiar to the property at issue, clearly constituting market exceptions to properties. Kind of went over this, but it's really, it's just that same unique condition. I guess we can go to the next one. Literal application of the code deprives the applicant of a substantial property right enjoyed by their owners in the same district. We think that, I think it's self-evident that privacy and ability to use a backyard is something that is a substantial property right and that he's not able to enjoy. Having a fence that can buffer between the public right-of-way and the private prop in someone's backyard is obviously something that he should have a right to have, and not necessarily need to rely on like plants and stuff. Like he should have a buffer. We can go to 14. Variance is a minimum criteria or minimum variance that will make possible reasonable use of the property, and a variance will be in harmony with the general purpose and intent of the ULDR, and the use as varied will not be incompatible with adjoining properties and will not be detrimental to the public welfare. We think this one is also met. In particular, there is a section in the code that speaks of the intent with fences and buffers, and it's to ease a transition between public ways and private property. And so not allowing for this variance would actually be counterproductive and would not serve the code, because it wouldn't be it wouldn't help ease a transition. That, like I said, there's a problem with privacy because of this situation. All right, and so I would just like to state for the record that I want it to be clear that I'm submitting this PowerPoint as well as the narrative and the attachments and the site exhibit into the evidence. I'd like to move that into the record if no one has an objection.
Moved into the record without objection.
Thank you. All right. So let me just make sure I haven't missed anything yet. Yeah, with regard to the not being self-created, I don't think I really touched on that too much. The code also requires that for a variance, it can't be self-created. So just wanted to be made clear that the client didn't create the flood zone situation. He didn't create the higher elevation compared to other properties. And that's just a result of the code and the fact that it's just a high-risk flood zone. So he didn't do it for ignorance of, he's not claiming ignorance. He's just in this situation and just wants to resolve it in the most narrow way possible. And as you'll hear in testimony, the fence is actually 21 feet long. So, it would be a lot worse if he actually had a higher perimeter fence all around the property. It's just a privacy panel, very limited in scope, just to protect him from the street in his backyard. There's also TVs back there. There's valuables of various kinds in the backyard. And so it's a concern on not just privacy level, but on protecting, from intrusion, from, risks of various kinds on the outside.
Very good, Mr. Ryan. Mr. Abrams, are you finished with your presentation in chief?
I am finished with the presentation in chief. I guess at this point we can just move to witness testimony.
Well, why don't we move to questions of your presentation by the board?
Yes.
Any board members have any questions with respect to the variance request or the presentation? Ms. Ellis?
Yes, Doug Reynolds.
Yes, Mr. Reynolds.
Yeah, I would like to ask the applicant's counsel, as I understand reading the record, it indicates that this home was rebuilt or built in 2019, correct?
That's correct.
Okay. And at that time, is there any reason why there was no permit sought for this fence back when the property was developed?
The perimeter fence was already there, is my understanding. And either way, the perimeter fence is on the property line, which is not at the higher grade. It's at the street level grade. So when my client purchased the property in 2019, after it was built, it was basically bare. There wasn't any landscaping. So when he got there, they put a substantial amount of money into the landscaping and into the pool area, and began using his backyard and realized that they couldn't really enjoy it with privacy. So they just tried to address the situation as narrowly and quickly as possible, which is just with a privacy panel rather than replacing the entire perimeter fence. That's the goal.
Well, I just want to understand the privacy panel you're referring to, the 21 feet, that's a new construction, correct?
Yes. Yes.
And why wasn't that permitted?
I think there was an oversight on the part of the landscape architect who's here to speak today. It's not something that he's, trying to pretend like he shouldn't have done. I think that we acknowledge that it should have been permitted. We're seeking the permit now, and that's kind of why we're at this variance stage, because the permit is pending, permit application.
Right. And so the landscape architects basically developed the landscape plans for the property, correct?
Correct.
Okay. And so why wouldn't this be self-inflicted?
Well, the code allows for a variance after the fact, and there's no penalty in the code for seeking a permit after construction is already built. So whether a variance was submitted before, a variance application was submitted before this was constructed or not, is not really the issue that I'm trying to portray.
I think you, Mr. Abrams, with all due respect, I think you missed Mr. Reynolds' question.
Okay.
You redid the house. You redid the landscaping. We now have a visual shielding problem that could have been solved during the rebuilding of the house, or could have been solved during the design of the landscaping, both of which would not have required a variance. So how is this the minimum variance necessary, or how is this not self-inflicted when two other methods during the house design, which happened in 2019, could have arguably solved this problem?
Understood. And I completely understand the question and the reason for it, and let me try to see if I can address it. So let's just go back and pretend my client, before building the privacy panel, addressed this in the initial landscaping. Nothing changes. Like he can put hedges. The perimeter fence was already there, remember. So like the perimeter fence is built to the line, and the grade, it's still going to be at the street level grade, which is not the same as the floor elevation grade of the property and the patio. So to gain the full extent, to actually use the full extent of their property, the fence is at the property line. So the grade really, it's going to be street level. So the fence is where, the height is at the city code limit, which is 6 foot 6 inches from the grade of the fence. So the problem is still there. There's a shielding issue, and yeah, they could have like put trees in or bushes, or hedges. But our point is that they should have a right to shield themselves from public view with a fence like anybody else, and they can't do that given the newer, higher grade of the actual structure and the patio. Is that? I could see that there's some facial expressions. So is there a reason that's objectionable? Let me know.
Well, my next question has to do with the fact that this area is a high risk zone, which you just pointed out for flooding.
Correct.
Right. So I don't want to make this floodgate argument, but the bottom line is, if we grant this based on your theory, based on the fact of the high risk zone, wouldn't that be something we would have to grant to everyone else in the high risk zone when they came in? They made the same argument.
Well, why wouldn't I have to grant it for second story shielding and go for a 27-foot high screen?
Well, because the question is not whether you should have privacy from your entire home. It's whether you should have the same level of privacy as others who are in the community in the same zoning district. And what we're saying is that in the backyard, he can't enjoy the same privacy rights as everyone else in the community, which is true. Even like every other home in this community is an older home built on a lower level grade, and the fencing requirements and the fencing height limit that the city's code provides for is actually something that was appropriate for the street level grade that exists, or the closest street level grade that exists in most homes that are in the neighborhood and in the city at large. So I think because the new code requirements in terms of the grade level haven't caught up to the fence height requirements, I just think that it creates this situation that makes him unique compared to all the other homes that have been there for a lot longer. And you know, we do feel that is a unique situation. And that's all the code requires. It's a unique situation, whether, you know.
Thank you, Mr. Abrams. Mr. Maxey.
I'm trying to understand the argument, and obviously we're, you know, sensitive to, you know, trying to build ourselves so that we're ready for the future of sea level rise and stuff. But, you know, I'm looking at the panel. I mean, the panel's 8 feet in height. So I'm just not understanding, is on the other side of the panel, is the height of the patio come up, you know, a foot and a half, or?
Yeah, the actual, so the base height of the structure, the house, like the bottom, the finished floor elevation of the house is at, I think I put 1 foot 7 inches, but it's actually 1 foot 6 inches, and you'll hear testimony from the landscape architect on that. And so basically what that creates is the actual, if you minus 1 foot 6 inches from the fence height of 6'6", you get 5 feet 6 inches. All right, I'm sorry, 6 feet 6 inches, which is exactly the height that the code provides for. So what I'm trying to say is the screening effect of the fence per the code allows for the equivalent of a 5 feet 6 inch fence, which is shorter than is intended for this particular property.
So that we're abundantly clear, because I think we've got a lot of math flying around.
Yeah. Sorry.
From the bottom of the privacy screen to the top of the privacy screen, what's the distance? Is it an 8 foot high privacy screen, or is it a privacy screen that goes up to 8 foot NGVD?
No, it's 8 foot height from the bottom of the privacy screen, the base of it, to the top of it. So the privacy panel itself is 8 feet high. Correct.
So if it went up instead 6 foot high, if it's at the lifted height, which is its base, would be your equivalent difference, wouldn't it? Because it's stepped in to where your property is elevated. So
no, it's actually, no, it's at, it is at the street level grade as well.
Okay.
Yeah. So that's the problem. You're right. If it was at the finished floor elevation, it would still show from the street as 8 feet, but it would be shorter from the base of it.
So, and I know there's some other board members who have questions. I have one more question before I go back. The property fronts on both 17th Terrace and 18th Street. Which street sides is the privacy wall on?
It's on the side of the property. Wait, were you asking the street, the actual street?
Right. Yeah. If this is protecting from the street view, is it 17th Terrace or 18th Street?
Oh, I have to look at the map. I'm sorry.
17th Terrace.
Is it 17th Terrace? Okay, thank you.
And just so we have a clear record, whose answer was that?
This is Gage Couch.
Thank you, Mr. Couch. I take it you're the LA.
Correct.
All right. Well, we'll ask you that after you introduce yourself. I know you're going to speak in a little bit, but thank you for the answer. Any more board questions?
Yes, Mr. Chair.
Yes, ma'am, Ms. Ellis.
Okay, so understanding a little bit of your discussion, sir, what I continue to hear you say is rights of privacy. And of course, we all would like privacy, no doubt. But that neighborhood, not everyone has a fence. Certainly, they're not all on corners, but there are corners in that neighborhood that don't have fences. So I understand, because of the pool area, the need for safety as much as privacy. Looking at what I saw, whether this body agrees with me or not, I actually see that as a feature. I do see it as a feature. Fences are fences. They don't have to be ugly. And this actually isn't acting as a fence. It's actually acting as an artistic feature as a screen.
And just to be clear, we did try to, the landscape architect in particular did try to negotiate that interpretation with the zoning staff, and they just couldn't come to an agreement, hence my involvement.
So I'm actually going to divert us for one quick second. Mr. Ford, are you on at the moment?
Yeah.
Is there a view of this privacy screen or minor amendments to this privacy screen that will? Hey,
we're getting a phone call from IT at the same time. Can you repeat that one more time, please?
Sure. Is there any discussion or review or modification that could be done to the privacy screen that would change it in staff's view from a fence to an architectural feature which would not require a variance?
I don't think so. We do give a little leeway to art, art itself, statues or something like that. We may allow some variance in that from the staff level, but not a section of fence.
Okay, what if it was just an architectural feature that actually did something architectural that sat between 6 and 8 feet?
Well,
that was a sconce or some actual architectural feature that could be done. How far do you think they would? Well, I'm not going to ask you to make a decision on the screen, but do you think that's a worthwhile discussion? Because if you think it is with the applicant and his landscape architect, I'm going to give the applicant's counsel the ability, if he wants to ask for this to be tabled while that discussion happens and brought back if a variance is still needed.
All right. So there is a section in the code that deals with architectural features atop fences. And
I was actually trying to pull it up while we were talking, but I couldn't get it up on my screen fast enough.
There's an allowance for an 18-inch architectural feature that can be put atop a fence, and it can be no more than, and I'm looking through the code myself, I believe 20% of the lineal footage of the fence along the property line that it's on. So there is an avenue to take, but I don't think that the city would consider just a square extension of the fence architectural, but if they did try to design something that was, then I think they could do that.
I've got a firm belief in Mr. Couch's creativity in design. So, Mr. Abrams, we can move forward with the hearing on the variance, or if you would like to ask for the matter to be tabled so Mr. Couch and yourself and the property owners can explore what they would need to do to change this into an architectural feature. The board would be willing to entertain that as well. And
if I could just say that architectural feature would be an addition to the existing fence.
Got it. Yeah. So, Mr. Abrams, I think what I'm going to do is yes, ma'am, or sir.
Yeah. That's something that I'm pretty sure, and I'll defer to my client who's on this meeting as well, Michael Dutzer. I'm pretty sure he's not going to be agreeable to that because of the fact that.
Well, why don't you take 5 minutes and chat with him offline, cell phone to cell phone, and we'll take a quick 5-minute break here, our only agenda item.
Okay. Okay.
Is there any objection to a 5-minute recess from the board? Seeing nobody vigorously shaking their head back and forth, I'll assume there is none. And we'll relax for 5 minutes. Why don't you guys chat? My strong advice, having been on a 3-day administrative hearing, is Mr. Abrams, before you get on the phone with your client, mute your microphone.
Thank you.
Made that mistake twice in the last couple days.
All right. Thanks.
Thanks.
Does anybody need anything from Wawa?
Good stuff.
I will tell you what, man. You know, heartbreaking going to a shelter, and now if you know the Everglades Rescue Shelter or the Everglades Rescue Group, who uses Siler is their staging area. They're pulling like 30 dogs a week out of the Everglades of people who just go out to, you know, US 27 or go out the Redlands and just abandon their dogs. Just
Wow.
toss the dog out of the car and leave.
I never heard that. That's terrible.
They estimate close to 1,000 dogs in the East Everglades because it's generational. You know, I don't think people who are willing to go abandon their dogs out there are really worrying about spaying or neutering them before they do that.
Right.
I'm going to go abandon my dog, but I better spay or neuter him before. Yeah. Mr. Abrams, you good to go?
Yes.
What would you like to do? You want to keep going, or would you like to?
Yeah, well, we've explored all avenues in good faith ahead of time, and we think that the city was using good faith too. It's not like they were not using good faith, but they made it clear that we would have to take that fence out. So I mean, the client spent a lot of money, and he thinks that it's necessary. So push forward.
Very good. So we were in the middle of questions. Mr. Reynolds, you had your questions. Mr. Maxey, Ms. Ellis, were you still in the middle of your questions?
Actually, I have a little bit more of a question, if I may.
Sure.
So,
I'm sorry, I apologize. I don't think we have confirmed if my client and the landscape architect Gage Couch has joined us again.
They're both on. I see them both on the screen.
They're both there? Okay, sorry about that. Okay, go ahead. Sorry.
No worries. So again, and I'm going to ask Bert this question. The percentage of the existing fence, if it were considered an architectural feature, what is that percentage? Or
Are you asking what the code allows for the amount of percentage?
Yes.
I think it's what is it in the field? Because it's 20% in the code. I think Miss Ellis is asking what percentage of that 17th terrace is covered by the higher fence. Right.
Well, what I'll have to do is I'll have to pull up the existing fence permit real quick, and I'll be able to tell you in a couple minutes.
Okay.
Great, thank you. And here's where I'm going with this. I know there's an existing fence on the property that's at the lower grade. It's at the street grade. This fence is at a higher grade. Depending on what that percentile is, it might be worth considering extending the higher fence for the length of 17th Way and measuring from that point of land as opposed to the street point, which is up. You're 1.5 feet, I believe you said. 1.7, 1.6, whatever it is.
Well, so the privacy panel is at the same grade as a perimeter fence. It just goes
same
higher.
bottom grade.
It
just extends 18 inches.
It's street level. So it goes 8 feet from street level. The other one perimeter fence goes 6 feet 6 inches.
Got it.
But when comparing to the finished floor elevation, which is 1 feet 6 inches higher, it's the same screening effect as what we're saying as a normal perimeter fence.
So what is the distance from the existing fence to the higher grade? Is it a couple of feet? I mean, is it possible to make that work?
Well,
that might be a good question for Mr. Couch, I think.
Yeah.
You think, Gina?
Yep, either one.
Okay.
All right, so let's hold for a second for Mr. Ford.
Yeah, I'm just trying to see how we can accommodate this in some fashion.
Yeah, Gage, hang on for a little bit until we call you.
So the original fence shows that they put in 120 lineal feet. So that would be 24 feet could have the 18-inch architectural feature along it.
Okay.
And how wide is it now? If it's wider than 24 feet?
I don't understand the question.
The screening fence that is in there, the 8-foot screening fence, how long is that?
Let me switch back to that real quick. Hang on.
21 feet.
Okay, 20.
So it would be within the 24 feet.
Correct.
Okay.
Okay.
Any more questions from the board? Do you want to introduce any other witnesses as part of your case in chief? Mr. Abrams.
Yes, Mr. Chairman, I would like to, I guess I'll first call Gage Couch, the landscape architect.
And Mr. Couch, have you been sworn in?
Yes, I have.
Can you please state your name and business address for the record?
Yes, Gage Couch with Cadence Landscape Architects, 435 North Andrews Avenue, Suite 2.
Bridget, did you get that? Okay.
Okay.
Have at it, Mr. Couch.
Well, hello, everyone. It's good to see a few familiar faces on here. Thank you guys for your time tonight. I think the last like minute of conversation that we just had was probably the most clear, and like what our intent was to consider that an architectural feature underneath the 20% allotted amount, and only put it in that section. And so, that was the intent. We initially designed landscape for there. If there wasn't enough buffer with all of the people coming by on the sidewalk adjacent to it, and then especially with the AT&T and utility workers on those boxes. So the client requested that we figure out a different solution, and so this was it. We tried to go back and forth several times with this intent with staff. I spoke directly with Anthony Fajardo as well to try to resolve this, and we were pointed in the direction of you guys. So here, this is where we stand.
And Gage, do you have, can you tell us just a little bit about your experience and background?
Yes, co-founder of Cadence Landscape Architects. We've been in Fort Lauderdale now for a little over 10 years. I've been living in Fort Lauderdale since 2005. So we work on a number of residential projects, condo projects, hotel projects, public parks all around town.
Okay, and can you talk a little bit about the grade for this finished, for the first floor, the finished floor elevation for this property? And
Yes.
talk a little bit about that.
So like Mr. Abrams already explained, the pool deck is 1 foot above the sidewalk grade, street grade, and then the finished floor elevation of the house steps up another 6 inches into that. So, when they are in their bedroom looking out, the 8-foot fence from the street side is actually only seen as at 6 foot 6 inches, which is the maximum allowable. But we are also thinking that it fell under that architectural feature part of the code as well. So there's a pool back there and a small retaining wall. So there's the grade does not slope up at all. It's flat from the sidewalk until it hits the side of the pool deck. And then it jumps up a foot, and then it goes across the pool deck, and then it jumps up 6 inches into the house.
Thank you. And just to confirm, the length of this privacy panel is 21 feet, correct?
I don't have those drawings in front of me to absolutely.
Approximately, like roughly.
Yes, it's
is that accurate?
Yes, around 20 feet, maybe 22 feet.
Okay. Okay. Do you think that this privacy panel was constructed in the most limited way reasonable to provide for the privacy that the owner requested?
I do.
All right. And you said that when accounting for the difference between the finished floor elevation and the 8-foot height of the privacy panel, it comes out to the same screening effect of about 6 foot 6 inches?
If you're at this elevation from the finished floor inside the house, correct.
Okay. And you determined that was an adequate height to ensure for an adequate buffer between the public right-of-way and the private property in the backyard, correct?
Well, yes, and we didn't want to go any taller than that to, go above and beyond what code allows. Okay,
thanks. And do you agree with everything I said today? I mean, is there anything I'm sorry?
I do agree.
Okay. The site exhibit that I entered into evidence, did you create that?
Yes, I did.
All right. And what was the purpose of that?
The purpose of that was to help illustrate the difference in elevations and also site views from inside the property and both outside the property.
Okay. And is that a true and accurate representation of the actual situation in that?
That is correct. It don't exist in the field.
Okay, thank you. All right. Anything else you want to offer into the record?
I don't think I have anything additional, but I'm happy to answer any more detailed questions from anybody.
Any questions from the board? I have some, but I'll hold mine till the end.
I have a question.
I didn't see who spoke.
Carrie?
I'm sorry?
Carrie?
Hey, Carrie.
Hey. My question is just, could you just address what consideration was given to using vegetation to provide the screen or to backing the relocating the 6-foot fence onto the elevated portion? You said there's a retaining wall. So I guess it's like there's a retaining wall and then, you know, it was just infilled within the retaining wall. So basically like building, I guess, taking down the perimeter fence and relocating it to the top of that retaining wall so that it would be on the higher portion, the elevated portion of the land. Were either of those considered and rejected for any reasons?
We didn't, the edge of the retaining wall is the coping of the pool as well. So we didn't want to put that directly on top of that coping.
What about using vegetation?
Vegetation. So, you know, to get a nice full buffer that's going to grow tall in there, we did not think that there's going to be any adequate plants that would give that same level of privacy. There's also 2 really large oak trees directly to the east that provide a lot of shade in that area. So, you know, finding plants that will grow, you know, and have a dense foliage and to a height that they needed in the shade is pretty tough.
Okay. So you considered that and it just wasn't going to work at this particular spot?
We did. Absolutely, we looked at that.
Thank you.
Thank you.
Any other questions from the board? Ms. Ellen.
Just again, having walked that sidewalk, I will tell you, I understand the challenge. And that's why I was interested in the footage, because it does, in fact, act as a screen, but it is kind of a cool feature as well. But having said that, I believe in your opening statement, you talked about no pushback from your neighbors. Do you have anything from your neighbors that speak in support of it?
That's your question.
That's your question.
I can answer that question. We didn't think to call upon anybody in particular. I kind of wish I had, now that you mentioned it, but no, I didn't.
But understanding that it was posted, so
right.
If someone have any objection to it, I can tell you from history, clearly they would have been here to speak. So
I figured.
Mr. Dutzer, hold on one moment. Let's get through any questions we have for Mr. Couch, and then we will let you speak. Any other board questions for Mr. Couch? All right, Mr. Couch, let me get into mine. And can you please put up—
Board, can
yes.
I interject for a second?
Yes, sir, Mr. Ford. Yeah.
So I did just check the application that was submitted, and I just want to update it to, it is 24 feet long, just so you know.
Okay.
But according to the application, I've never been on site. And we do have 3 people lined up who do want to speak for or against.
Right. Okay, perfect. So Mr. Couch, I want to bring you back to some elevation perspectives. And I'm looking at the semi-aerial picture that shows the very nice lap pool and the privacy fence, and then all the way to the left shows the AT&T box. Can our IT assistant get that picture from the application package up on the screen? Or any one of the pictures from the street side, looking at the fence. Go up, go up a little bit more. No, right there, perfect. This one right here. And it is the leftmost fence. So I'm looking at the layout, and the existing boundary wall is 6 foot 6 inches high at the street side. And anybody whose eye level is less than 6 foot 6 inches high is going to be looking at an up angle as opposed to a down angle to look through that fence and see into the property. And I'm assuming there's not a lot of 6 foot 10, 7 foot people walking around, but there may be a few. So as I look into the property, I see a very narrow landscape strip, a pool outside coping that is dangerously thin to stand on, and then in the area covered by the privacy fence, you don't start getting to a point where you're standing at deck elevation until the interior edge of the pool. So Mr. Couch, can you explain to me from an elevation perspective sense, either how tall someone would have to be at the street level, or how tall someone would have to be on the pool deck level for them to actually be seen from the inside and the inside of the property from the outside?
So, I mean, that's a tough question. I think, you know, anywhere, like if you have somebody that's probably anywhere from like, you know, 5 feet tall or taller on the inside pool deck, you can see them from the sidewalk.
Explain to me from a perspective point of view. I'm on a very good day, I'm 5'9". If I'm standing next to the AT&T thing and looking at a 6 foot 6 fence to see anything, I'm looking at an up view. So explain the distance of that perspective at that angle, because I would think that person would have to be about 7 feet tall for me to see the top of their head inside.
I mean, I think that's more, you need to see it on site, how it actually works. If you're standing directly up against the fence, looking at the fence, of course, you're not going to see anything. But as soon as you start stepping back, your eye level can see slightly over the top of the fence to the backyard.
And if I also may, we submitted the site exhibit for that reason, because we understood there might be some confusion for those who have not been on site. So if you want, I can put that up also to help gauge.
Well, if it doesn't have a perspective view, which is what I would normally expect to see something in a package that's a visual blocking type of package, unless it has a site perspective, that's not going to help to answer the question, which is really, what is it that's being blocked? It may be that the view of the street from the interior of the pool deck may be getting blocked, but you'd have to be across the street to see something inside, unless I'm missing my perspective guess.
I'm going to go through my various application and look through the photos. There might be one in there.
Well, again, I think Mr. Couch would know if he prepared a perspective view with the site angles. I think that's what I was looking at. Did anybody examine the site angles to see what's really getting blocked on the inside?
I think it's also, you know, if you look at it from the view when you're looking out as well and not seeing people, I think it's a very situational thing, you know, to be out there and really understand it. These pictures really don't do it as much justice as what it is.
No, I've got it from my backyard deck. I can see over the top of the 6 foot, my neighbor's 6 foot 6 inch fence. And to accommodate that, we actually put shrubs in along that line that go higher than 6 foot 6 to block our view into their backyard. So I understand that. I'm just wondering, when you went through the landscape design for this line, why that didn't get really fully considered.
Landscape material options?
The landscape material options, or even an actual architectural feature that would have held landscaping that would have been 1.5 feet high on top of the fence for those 2 feet.
That was just, this was the design option that
Got it.
was decided upon. And
I hear you. The problem is, and one of the things about permitting is, you know very well, you've permitted a lot of projects in the city, is the permitting process. Were you to have gone through that before you built the fence, would have resolved these issues out, and you would have ended up with an architectural feature that was permittable as opposed to a vertical screen that you have to go get a variance for. And that's the problem that you guys find yourself in, and this board finds itself in looking at trying to grant an after the fact variance for something when there's a ton of other alternatives that could have been put in there that wouldn't have needed a variance.
So Mr. Chair,
yes, ma'am.
speaking once again to having been on site, I will tell you those trees that are in the swale area don't lend themselves to including that kind of foliage going up that high. Then you've created the tunnel effect in that sidewalk area, which is a public sidewalk. The screen that's there, and again, whether it would be something I would pick or not, is it's a open weave screen so that it's clearly, when you look at it from the site, isn't meant to look like a fence.
Right.
I mean, it's not designed to appear that way. It does not give that appearance. And again, it's spaced such that it's not obstructive. So while there are a lot of alternatives, apparently this is the one that they picked, and this is the one that's before us.
Yes.
And when I guess whenever it's done, I'd like the opportunity to show one photo to Gage and just get his input on it whenever he's done with your questions.
I have a question.
Yes, sir.
This may go more to the owner whenever he starts speaking, but it seems to me, and I could be wrong, but it looks like that this sidewalk dead ends just past the utility box. Like, this is not a sidewalk that anyone's using. It ends right there. It's not contiguous. I mean, like, for the picture that we're seeing, and maybe I'm wrong, maybe I'm looking at an old picture, but Gina did a site visit, so maybe she knows, I don't know, but certainly the owner knows. The picture that we're looking at on the screen right now, at the very bottom, right where the sidewalk goes into the words aerial view, my understanding is that the sidewalk literally ends right there. So this isn't, and I think that kind of cuts both ways. Like, one, there's no one really walking on the sidewalk to be looking over the fence, but at the same time, there's not really anyone walking on the sidewalk to be offended by this screen either. And it sounds like it's the men constantly coming and working at that utility box, which, that utility box is stepped back from the fence and slightly elevated. It's on a concrete pad, which is on a bed of mulch. So maybe it's 4 inches higher. So you got a 6-foot guy standing up on that pad to work on that utility box, stepped back 5 feet from the fence. I mean, I guess that's the real issue, because I don't think there's anyone really using this sidewalk.
Well, why don't we do this? Are there any more questions for Mr. Couch? Because I know Mr. Dutzer is dying to speak, and I want to give him the chance, obviously. Any more questions for Mr. Couch?
I got one thing I just want to show him real quick on my screen, if that's all right. It's just one of the photos that are attached to the variance. If the board will permit it.
I'm trying to figure out, who do you want to show that to?
Mr. Couch.
Sure.
Okay. Just if I can share my screen, I'm gonna try to do that.
Go right ahead.
Thank you. All right. So this is one of the images included in the variance application.
All right, so hold on, because you've got a little bit of a delay before it pops up.
Can you let me know when you can see it?
I can see it.
All right. Okay. So Gage, the perimeter fence is 6 foot 6 inches high, right?
Yes.
Is that correct?
Yes.
All right. And I mean, if the privacy panel is 8 feet high, I mean, that's essentially, we can see it right from this image that from the edge of the sidewalk, there is an approximately, correct me if I'm wrong, but about 18 inches between the perimeter fence and the privacy panel, right?
Yes.
So if you subtract 18 inches, from the 8 foot, it's got the 6 foot high, but you can see from this distance back, if you're looking in from the sidewalk, you can see a 6 foot 6 inch high person, no problem, from the other side of the fence. I mean, would you agree with that from this angle?
So I don't know. I don't know what the elevation of this angle was, but it definitely was. It's lower than what my eye level was. So I don't think
that camera was pointing at the house.
Accurate of an eye level photo. It would
That's true too. I guess all I was trying.
Mr. Abrams, your counsel here. You want to know if you could show something from Mr. Couch's testimony? I don't know that we're having a coffee chat between the two of you guys. If you have a question to ask him, let him testify, and let's move on. Let's let your client speak.
Fair enough. I guess all I'm trying to say is from this distance gauge, would you say that you can see, without the privacy panel, you can see well into the property over the perimeter fence?
Yes, if you're on site, you can.
Okay. But let me follow up with that, Mr. Couch. You can see, because you can clearly see the privacy screen sitting there, the 1.5 feet of the privacy screen. And that is, I think you testified, basically abutting the back of the fence, correct?
There's a separation between the privacy screen and the fence of about 2 feet or 3 feet.
Okay, and there's nobody using that area in between, correct?
No.
So what's on the inside of the privacy screen?
In between the two?
No, on the inside edge, on the pool side of the privacy screen.
Then you have
what's
probably like another 24 inches and then the pool coping.
So what's in that 24 inches? Is it patio?
It's planting.
Is it entertainment area? It's planting. And nobody's standing in there. And then you've got the pool coping. And is anybody standing on that pool coping edge having cocktails?
That I can't answer that question.
Okay, and then on the inside of the pool coping, you've got the pool, correct?
Correct.
Anybody standing on top of the water in the pool?
Not that I'm aware of.
So again, how far into the property at this point from the outside perimeter fence are you realistically seeing somebody standing at patio level? How many feet inside? It's not in the 2 feet. Yeah, it's not in the 2 feet between the exterior fence and the privacy screen, and it's not in the 2 feet of the landscaping, and it's not in the 6 feet width of the pool. So that's 10 or 11 feet right there, correct?
Probably somewhere between like around 15 feet.
So again, going from the perspective level of a view angle, if a 6 foot high person is standing on the sidewalk, how tall does that person standing 15 feet in have to be seen? Because it's an upward perspective.
I don't have the exact answer on height for that.
Okay.
But my guess, like I said earlier, would probably be somewhere around 5 feet.
Okay, I will admit, having done presentations and hearings for the last 30 years, including architectural presentations and perspectives, I miss your math on that.
Okay, understood.
Okay. Any more questions for Mr. Couch? I believe, Mr. Abrams, your client was next on your list.
Yes, that's correct, Michael Dutzer.
Mr. Dutzer, have you been sworn?
Yes.
All right, and while we know you're Mr. Dutzer, we know this is your address, for the record, if you could just say your name and address, so we're clear on the record.
1725 Northeast 18th Street.
And Mr. Abrams, are you going to be asking Mr. Dutzer questions, or is Mr.
Yes,
Dutzer
yes.
making his
All right,
own
thank you.
presentation? Okay.
Yes. No, I'm going to be asking questions. Thank you.
Okay.
Michael, how long have you lived at this property for?
Purchased the property in March of 2019, moved in within about 60 days after that.
Okay. Real quick, have you listened to everything that myself and Mr. Couch has said here today?
Yes.
During this hearing?
Yes.
Okay. And is everything you've heard true and accurate to the best of your knowledge?
Yes.
And do you adopt specifically what I've said on your behalf as your own testimony?
Yeah.
Okay. So can you tell us why why you had this privacy panel built?
Yeah, so I can kind of answer some of the questions that have been asked as well. So when we purchased the home, we moved from Key West. We moved here to be closer to a better airport. So when we found this home, the home was already built. We didn't build this house. It was done this way. The fence, everything was there. When you buy it, you don't realize some of the issues with location and everything. There was one house on this property prior to this house being built. The house was knocked down by a developer and 2 homes were built in its place. Our house was put on the corner, and the way the front of the house is on Northeast 18th Street, and the side of the house is built along Northeast 17th Terrace. Now, the back of the house is actually an L shape. So our living room has double doors to the pool, and then it turns and our bedroom looks directly into the pool with glass double doors as well. When you wake up and you see people standing outside the fence looking into your yard, it's kind of disturbing. And to answer the question before, yes, the sidewalk does dead end there. So you think people wouldn't walk there? You're wrong. Because the neighborhood is older, there are barely any sidewalks in this neighborhood. It's one of the few blocks that actually has a sidewalk running up in front and along the side of the house. Everybody else, so when everybody walks or bikes, it's one of the few streets that connects directly to Federal from 15th, like from Sunrise because of the waterways and stuff. So it's a very high traffic area, both vehicle traffic and foot traffic and bike traffic. People actually do walk off the street because they have no other choice but to walk on the street, and they get on the sidewalk. All my neighbors walk their dogs on that street. All their dogs go to the bathroom in that swell next to my thing. They all stand there. The AT&T people work there 2 to 3 times a week. And it's actually very intrusive when they're standing there working for 3 hours and you're either in your pool or in your house and they're standing there looking at you. And if you think that the fence isn't high enough, they are. That back box, which is an AT&T box, is only 18 inches away from my fence. So they're standing there like literally looking into the fence at all times. We did look at the option of putting hedges in there, but because of the presence of the pool, we were concerned with roots going into the pool and leaves also being into the pool constantly. And the only way to maintain hedges would be from inside the pool, because there wasn't enough distance to get hedges that tall in between where the pool is and the decking and the sidewalk. We considered those options when we looked at it with Gage, and we decided to go with the wall. But and right now it's even more so because they're doing all this SOAR work, and since March, Northeast 18th Street is shut off at just past 17th Terrace. And so all the traffic is directed along the side of our house on that wall.
Thank you.
Mr. Dutzer, anything else?
Yes, I just wanted to pull up a quick picture. If you'll indulge, sorry, 1 second.
And now, mind you, we spent like $100,000 on landscaping. And like I said, when we went to Gage, one of our biggest concerns was privacy, because we would people would pop their head up and talk to us in there, which is fine. I know people you move into a neighborhood, people want to get to know you. They have questions. We did all this work. People want to see it. And we get compliments all the time for it. I've never heard one of my neighbors complain about it. The people actually walk up and, ask to see the backyard and stuff. And I get it. Like we're new in the area and people are interested and they see you outside and they want to talk to you. And you're the way the decking is installed, you are up on a platform. So people do see you. All you have to do is look up. I'm 6'3". And one of the things we looked at is when you're driving down the street, you look right into the pool area, right into the bedroom. When you're walking over there, I can see the top of my bed standing at the AT&T box out along the road.
Thanks, Michael. In the backyard there.
It wasn't like we just, randomly, put a wall up there. We did have concerns. We were uncomfortable.
And do you have valuables in the backyard? Like you have a TV, correct?
We do. The picture you're looking at now, over under the decking there's like an outdoor living room, and there is like a 75-inch television installed on that wall. So the privacy panel also provides security from seeing what's inside the yard, which, there is a lot of theft in this neighborhood as far as like bikes and packages and stuff. So it does provide an extra layer of security visually from inside our house, because also past to the right there are, I think it's blocked by our pictures, but that's the view into our living room. And then directly across from the pool is our master bedroom.
Got it. And you've invested a substantial amount in adding and making landscape renovations, including this fence or this privacy panel, correct?
Yeah, the total cost was a little over $100,000 to redo the landscaping. And it's actually meticulously, Gage's company, Gage and George at Cadence, hand manicure the landscaping twice a month for us.
Right, and would you say this fence adds to the aesthetic value of the community?
Yes, I mean, like I said, nobody's ever, if anybody was going to complain, they haven't complained to me. I've only gotten compliments. And like I said, taking that privacy wall down only gives them a view of another wall, and that's my bedroom wall. So to me, it gives me the privacy that I feel I needed. Without, like I said, those trees are there. We could put hedges there, but I just felt it was going to be more of a maintenance problem for the pool, and then also with hedges that size, a root problem coming through the side of the pool. Because like I said, that pool there where you see the oolite columns installed drop down about 1.7 inches down below the ground. So the root system of the bushes would be along the entire middle of the pool. If we did hedges along the entire pool, that it would be right up against the pool.
Yeah, but it wouldn't provide the equivalent screening effect as a privacy panel such as the one that you have created here, correct?
I mean, it could have, but even this picture here, the plants that are planted alongside the pool there, they've burned. We've already had to replace them out because the sun beating down during the summer when the sun's over the front of the house, the sunlight that it gets, it burns them. So they've already had to be replaced out. So I don't know how they would have, if hedges would have survived there with the direct sun from that side, or even the shading from the trees that are behind it. There's two giant trees that pretty much canopy that entire section over the fence.
But there's no equivalent permanent screening effect compared to this fence that you've created, this privacy panel. Is that right?
I mean, the panel couldn't be installed on top of the decking because of the pool. I mean, the decking is, I don't even know if it's a foot wide along the back of the pool there. I couldn't even walk it. So like maintaining hedges or something from that edge of the pool, I couldn't do it unless you were in the pool to maintain them. Like I don't know that it would have been easily accomplished without putting a ladder in the pool to maintain them.
Just a few more questions. Going through the elements that we're required to show here today, are there special site conditions that are preventing like reasonable use of this property in your view?
Now?
No, before this, I'm sorry, before this privacy panel, were there?
Outside before. Like I said, I'm a private person. We both have high profile jobs, and I take my security very personally. I have cameras surrounding my property. I didn't feel like I had privacy. Even now, and with the signs from the city in front of the house, I've had people taking pictures of the house, taking pictures of the sign, putting their phones over the fence, taking pictures. It's actually been pretty disturbing to me. I had to ask some ladies who walked into my gate the other day to leave the property. Yeah, I find it very invasive.
So the discussion, the conditions that we've discussed here today about your property, would you, in your view, are those, and having been in your neighborhood for some time now, are they different than any other property in the neighborhood? Are they more?
Well, yeah,
are they?
It's an older neighborhood. All the houses are built lower. Our property, they raised the elevation of our house. So our house sits higher than any other property. If you look at the house across the street from me, or the house in back of me, or the house across 18th Street, all the houses are at street level. So if you have a fence, and most people's side or backyards have a 6.5 foot fence around them, but they're covered because their yards and their properties are at street level. Our house is new in the neighborhood. When they knocked it down, they elevated the grade of the house. So the house actually sits higher than our fence does. Our fence is no higher than any other fence in the property, but our house is much higher than every other house in the neighborhood. And like I said, our sidewalk, we're like one of maybe 3 blocks in the entire neighborhood that has sidewalks surrounding the house. I could count probably 20 to 30 people a day walking their dogs along that swell there, because otherwise they're standing in the street with traffic. So that actually is a very high traffic area for pedestrian traffic because of that reason. And if you're coming down the street, like if you look at a fence, like a wall that's 6.5 feet high, like the fence is 6.5 feet wall, when you're coming down the street and you're standing 2 feet above that, you are seeing into the yard, you are seeing into the pool area from when you're in the street. So when you're naturally next to it, people look in. It's what they do, unfortunately.
And just to be clear, a 6'6" perimeter fence would deprive you of the ability to enjoy your backyard in privacy. Is that right?
Yes. Because like I said, then we go back to the old problem where people can look into the house.
Okay. And do you view that as a substantial property right?
Yes.
And it's one that is enjoyed by all of your neighbors in the community and your neighborhood, correct?
Yes.
All right. Did you create the flood zone that you're in?
No.
All right. And did you create the higher elevation that's required by the city?
No.
Your property?
No.
Okay. Is this privacy panel that has been created by Mr. Couch, does that provide separation between your private property and the public right of way?
Yes.
All right. And do you think that's in harmony with the, or let me rephrase that. Do you think that's compatible with the adjoining properties, your neighboring properties?
I mean, I guess that would be up to my neighbors, but I feel it's visually appealing to the neighborhood. I don't feel I would imagine that they'd rather look at the wall than see me running around the yard. So,
all right,
your imagination on that. But I live in Florida. I have a pool outside. I enjoy it as I would like to, and I would like people not to see all of it.
Michael, is there anything else you'd like to share?
No.
Thank you, Mr. Gutter. Mr. Abrams.
Well, there is actually one thing. We also do have 2 daughters that visit us on weekends, and they do use the pool. And yes, it is kind of unsettling when there's guys standing out working in these utility boxes, and our kids are in the pool, and they're standing there watching us. So that is another factor. And maybe it's not important to you, but for me, a sense of security is very important. And it's my feeling that this helps, whether anybody else sees it that way or not.
Thank you.
You're welcome.
Mr. Abrams, is this the end of your case in chief? Those are your witnesses? And we'll reserve time
Yeah,
for
I mean,
rebuttal if you need it.
Yes, it's the end of my case, Chief. However, I'd like the opportunity to make a closing argument at some point.
Well, we'll let you have rebuttal before we finish. We're going to open it up for the public in a second. But before we do, any board questions for Mr. Dutzer? I'm not seeing any. Can we take down the screen share for the moment? And then we're going to open it up. I understand we've got a queue of members of the public who do want to speak. Shaquila, do we have them queued up?
Mauricio, can you please pull up? We have Caesar. Is he present?
I don't see Caesar, but I do see Richard Stone.
Okay. We also have, well, for this particular case, is Ivan present?
He was earlier, about an hour and a half ago, he was.
Okay. What about Andrea?
I believe I saw her on before as well.
Okay. So there's...
Okay, so the only one who's still there is Caesar?
No, sir. The only one that it's visible for me to see is Richard Stone.
Okay. Do we want to let Mr. Stone in?
So according to the comment card, he's there for the other case that was pulled for tonight's meeting.
We might want to let him know. So outside of the fact that our board hearings are always entertaining, I don't think he really wants to sit here
he just left.
only to find out that he's not up. So we have, yeah.
I actually just moved Richard Stone into the call right now.
Okay, sorry.
So Mr. Stone, you might be here for the wrong agenda item. Are you here for
0005?
Got it. That is unfortunately was misadvertised and will be brought back to our November meeting.
Okay, thank you for that. I would have wasted more time.
Yeah, I'm sorry we weren't able to tell you that earlier.
It's fine. Thank you very much for your service. Take care.
Okay, so we've opened the public hearing. I'm hearing no members of the public.
Chair?
Yes, ma'am.
We also have a Robert Strickland. He didn't sign up, but he's as an attendee.
He works for the city. He's doing recording.
Over. Okay.
Yeah, he's
unless he wants to hop in and explain to us the background, I think we're probably good. So, sensing no members of the public, I will close the public forum. And Mr. Abrams, I'm going to give you a chance to summarize and close, and then we'll go to board discussion. And if we have a motion, we'll go to a motion. So 5 minutes, sir.
Okay, it'll be shorter than that. I appreciate all of your time tonight and listening to this matter. This is obviously very important for the owner. I don't want to understate that. It's really a matter for him, between being able to enjoy his property or his backyard or not. And there's really no reason. I think we've demonstrated that there's no reasonable substitute for what we've done. And also no substitute that is as aesthetically appealing as the current one that we have shown to this board. It has a lot of time went into it, a lot of money went into it, and it is visually very appealing. I just want to just state that our burden today is to establish these elements for variance, as the board knows, by preponderance of the evidence. And not that it's a surprise, but like if we are able to establish that burden, it's there's no discretion, and we feel that we have met these elements, and that we've met them satisfactorily. And I just want to review them and explain again why. The first criterion is that there are special conditions and circumstances that affect the property addition, which prevent the reasonable use of this property. So there are numerous special conditions here that we've identified that are unique to this property. One is that we're in a FEMA high-risk flood zone, and the city code requires this property to be at a higher elevation. The result has been a 1 foot 6 inch difference between the finished floor elevation of the structure and the top of the perimeter fence. So this has resulted in a reduced screening effect when complying with the city code, which results in my client not being able to enjoy his backyard like any other property in the neighborhood. And being that there's mostly older homes and that there's not much he can do about the location of the perimeter fence. That's one. And the other is the fact that there's several utility boxes right outside of his property. You've heard testimony that there's known to be workers servicing those boxes, sometimes up to multiple hours, and he has to be in his, endure that. He has his family there. He wants to protect them. He wants to protect his valuables. These are unique conditions that he has a right to special treatment for being able to have a buffer against. And that's all he's trying to do. And this is just reasonable use. That's all he's trying to get here. Again, you heard testimony also, the sidewalk is not something that you see around the neighborhood. It's really just in this area. And so a lot of people do frequent that sidewalk. And so there was increased traffic right around his property, and he's got sidewalk. He's on a corner property. So these are special conditions. So the first element is more than satisfied by preponderance of the evidence. The second element, circumstances causing special condition is peculiar to the property issue, clearly constituting a marked exception. We have a flood zone. We have a height difference of 1 foot 6 inch due to the increased floor elevation. So I don't want to, beat on this point too hard, but I think we've covered it. It is a unique exception to the norm in this neighborhood. So the second element has been demonstrated. And the third element, literal application of the code deprives the applicant of a substantial property right enjoyed by other property owners in the same zoning district. Privacy is a substantial property right within the confines of a residential property, a single family residential property. They are entitled to the privacy within their backyard, particularly when there is a fence. There is a right in this state to put a fence up and protect and establish clear boundaries from the public. What that does, it actually creates an obligation to others, notice to others that they're not allowed to enter. And so it's important to have a fence. Everybody's allowed to have a fence. The problem is that he's not able to get the full value of having a fence compared to everyone else in the zoning district. And so the third element is definitely satisfied as well. The fourth element, unique hardship, is not self-created by the applicant or his predecessors, nor the result of mere disregard for or ignorance of the provisions of the code. This is something that there was questions raised about. It is not something that was created. We've covered the fact that we have no control over the fact that it's a high-risk flood zone, that it's a higher elevation than every other one in this community. He didn't create that. And it doesn't really, I understand that it may hurt some credibility that the fence was initially constructed without a permit. However, I just want to emphasize that doesn't really, although we're correcting it now, it doesn't make a difference in terms of why we're here and why we need a variance from the code in order to enjoy full property rights. Either way, we would have needed a screening effect of something additional to the normal 6 foot 6 inch perimeter fence. And the fact that we did it after the fact, the code doesn't have any specific penalty for that. It allows for after the fact permits, and it also allows for after the fact variances. So there shouldn't be any difference in treatment there. The issue before this board is whether we have established a unique hardship, one that is not self-created by the applicant, and one that deprives them of substantial property right. We think we've met that. And the final one is, and this is an important one, is the variance, the minimum variance that will make it possible to get a reasonable use of the property. It's got several subparts in that one, and that's one. We think it is the minimum. We've established that with the testimony and the evidence we've submitted. It's the minimum height necessary to equate with a 6 foot 6 inch fence in terms of the screening effect. We've showed that. It provides for the length of the fence is only 24 inches. You've heard testimony that matches with a 20% threshold. So and it only covers the backyard area. So it's not extending lengthwise too long. The other part of that criterion is it in harmony with the general purpose and intent of the ULDR? This is important. We address this in the application. The purpose stated in the code on fences is you need to provide a buffer, a transition between the public right-of-way and the private property. This guarantees that. Without it, there is no transition. So it's necessary to allow for variance in this situation, to allow for a fair transition, a compatible transition. Another thing is you haven't heard any objections today from the community. The provision provides for a, you have to show that it's compatible with the surrounding properties, that it's not detrimental to the public welfare. You haven't heard any opposition today. This was properly noticed. You've heard testimony that there's been nothing but compliments from the community. So we have shown by the testimony, by the evidence, that this is beneficial to the community, that it's a net benefit. So we think that we've met this more than preponderance by the evidence. We're not required to show clear and convincing evidence. The fact that we can't show exactly the height of an individual and mathematically exactly what those thresholds are, that's more of a clear, convincing burden. We're at a preponderance of the evidence. We feel we've met that, and we think that there's no discretion to deny this. So we just want to respectfully request that the board take that into consideration and grant the requested relief, which is as narrow as possible. And any questions, I'm happy to answer.
Thank you, Mr. Abrams. Before we turn it over, and we're going to close the public hearing. Before we turn it over for board discussion, I do have one question for Mr. Ford, and I might have missed it. Yes,
Chair,
yes,
excuse me,
ma'am.
I'm sorry. We just had another call-in as he was presenting.
In that case, we're not closing the public hearing, and Mr. Abrams, I'll give you a right to rebut after this comment. But while we're waiting to connect that person in for the public hearing portion, Mr. Ford, I'm not seeing, and I might have missed it, any affidavit of posting in this package. Was one submitted to the city?
Affidavit for posting?
Yeah. And I might have missed it.
Yes, there is, but when he submitted it, it was after the packages had gone out, which is 5 days.
But we do have an affidavit of posting in the file.
Yes, I do.
Okay.
Yes.
And just we did provide an email before the 5-day period, but okay.
Okay. Yeah. The question was directed to staff. We've got a member of the public, Ms. Crawford. Who do we have?
Mauricio, can you bring this person over from the phone number that I'm looking at?
Phone number
As
ending
an
in
attendee?
3936. Could you please hit *6 to unmute yourself? Again, phone number ending in.
Yeah, we go. He or she is unmuted.
I'm not sure if this is Robert. I'm doing the recording. So I just was listening in that way on the phone from BIS.
Got it. Okay.
Okay.
So do we not have a member of the public? Mr. Abrams, you may be spared from a reclosing in this instance.
Okay.
In that case, I'm going to reclose the public hearing. I've gotten my answer from staff on the affidavit of posting. Board discussion, and I'll entertain a motion during the board discussion.
Here, I have a question for staff.
Go ahead, Mr. Maxey.
Mr. Ford, from my understanding, what you had talked about earlier, in the code, the architectural design has to be on top of the existing fence at the edge, and that can be 18 inches above the maximum height, which is 6'6", which gets it actually to 8 feet. Is there anything outside of the setback that would prevent the existing screen, 8-foot screen, from being part of an architectural design of something that extended 2 feet on top of the fence? When I'm actually like the design is imagine a lattice or something that you could see through that has an architectural design, and that the 8-foot screen would provide some sort of color and depth perception. Is there any issue with having the screen behind an 8-foot, fence with architectural piece above it, outside of the violation of the 2 inches on the setback?
So what I'm going to do is I'm going to read the section, and it's pretty specific. All fences may include architectural features and light fixtures along the top of the fence and gate. So it doesn't really.
Right. But Bert, does it define what an architectural feature is, or is that at the discretion of staff? Because I don't see a definition for architectural feature in the definition sections of the code.
There is a definition of architectural feature in the accessory use section.
I guess more importantly, my question is if that were to be in place, if there was an architectural feature of 2 feet placed on that section of the fence, is there anything wrong with the privacy screen behind it if it was at a 3-foot setback?
Again, I don't think the code allows for an architectural feature that's associated with the fence that was installed to be anywhere but on top of the fence.
No, I understand. I'm saying if there's an 8-foot, let's say there's an architectural feature that takes it to 8 feet, and let's say that the screen was 3 feet behind it, is there any issue with having a 8-foot screen behind it, behind an 8-foot fence with architectural feature?
Right. It's not on the property boundary. It's not a fence that encloses the part of the yard. It is just a vertical feature that sits behind the existing permittable fence and permittable architectural feature at the street.
Does that make sense, Mr. Ford?
Well, to me, I can't tell you if this square 8-foot fence-like structure is an architectural feature. So to me, if I look at something, I'm also a general contractor. If I look at it and it's built like a fence, I have to tell you that it's a fence.
No, but what's prevent me from putting an 8-foot structure anywhere on my property? Is there anything that prevents me from doing that as long as it's not in the setback, as long as it's, behind a existing 8-foot fence?
Yeah. So if it's going to be considered an 8-foot structure, it cannot be in any corner yard, can't be in any side yard, any rear yard. Or
which is just the setback issues, but not, you can still build something like that.
As long as it's not in the setback.
Correct, right. So that's a 2-inch
You would need a setback variance.
Yeah, so.
Not an actual 8-foot tall variance, because it's behind a fence that has an architectural feature that takes it up to 8 feet.
Yeah, but in this case, it would be in the corner yard. It would have to be. It would have to be back significant amount to
a
be
variance for a corner yard as well, is what you're saying.
Right, exactly. So this lot is, I'm looking at the survey, and it looks like it's 60 foot wide. So the code says that the corner yard is 25% of the width of the lot. So that would be 15 feet. So if there was an 8-foot structure outside of that 18-foot side yard, then it could be permitted as an accessory structure. But if it's in the side yard, then it's not permitted for that reason. Not that it's 8 foot high, but that it's a structure within the corner yard setback.
And can you measure that to see if that's the case?
Well, according to the site plan that they submitted, the 8-foot tall structure is 2 foot 10 inches from the property line, from the corner yard property line. So it's within the 15-foot corner yard.
So they would need a setback for that.
Right.
Okay, that's that would be something I would be willing to ask the council and the house owner if they'd be considering something of that nature in order to reduce the variance requested from the 8 foot to just set back into the corner yard. As long as that they could somehow incorporate.
Chadwick, aren't you just swapping variances for variances?
No, because at that point, you could say that if you can incorporate the screen as part of the architect on top of, or as part of the visual architecture on top of the fence, then you could say that is a.
I mean, honestly, as long as we're in board discussion, wouldn't they be better off appealing the determination that it's not an architectural feat?
Well, no, because if the code specifically says it has to be attached to the top of the fence, then you're not really looking at the spirit of the
run
code.
some attachment to it. And I've heard several board members so far here say it looks like an architectural feature to me during this discussion.
But can an architectural feature be, like Chad said, can it be like lattice work, like contiguous lattice work? Or does it mean like, a sconce and then 4 feet and a sconce and 4 feet and a sconce?
One of my neighbors has an architectural feature on top of their fence, and it is a running lattice work that they have planted in through planter boxes so that the root structures don't go down because of the same concern that Mr. Dutzer had. And they've got alamanda, which grows pretty thick even in nominal shade conditions, that runs through the lattice work, and you can't see a single thing through. And they did it as an architectural feature of 1.5 feet on top of the fence, and then the alamanda grows another 6-7 inches on top of the lattice work. But so that's neither here nor there. We've got a variance request in front of us. Should it be successful, then that's the end of the inquiry. Should it not be successful, then maybe Mr. Abrams has heard a couple of alternatives to go to. Any more board discussion? Mr. McTeague.
I have a question for Mr. Ford. Bert, has city staff addressed this or thought about this on from a staff's perspective? Because I build new houses. In almost every house I've built, the elevation of the finished floor is substantially higher than the old house next to it. I've stood in a few of my houses and feel like the finished floor is halfway up the other house. So I'm experiencing a number of situations where a 6-foot fence does not provide any kind of shielding to the new house. But, are we how do we resolve that? Because again, you're seeing it all over the city right now, actually, wherever there's new construction. So it's not unique to this corner.
No, and that might be an interesting discussion for an amendment to the fence code so that it actually more ably provides for this circumstance.
Yeah, at least it should be contemplated and so forth, because otherwise you just screen it with landscaping and so forth. Because there is significant height difference with the new construction and the required finished floor levels with the new FEMA flood maps and so forth.
Mm-hmm.
And then another thing with the first fence that was installed at the applicant's house, that 6'6" fence seemed to have a 1-inch gap between every board. So it didn't matter so much the height. I think that these people at the FPNL can see through every board section of that original first fence. So it probably was like looking through a sieve.
Especially if they're short like me.
I'm short too, yeah, so I don't see over a 6 fence. But I mean, again, there was lines through every board.
It's that whole horizontal fence line.
You could go up and down, yeah, so I mean, it was totally visible.
All right, well, any other board discussion? Otherwise, I'll entertain a motion.
Mr. Chair, I just had a quick question. Again, I think in its current format, I'm not sure that it follows the code to a degree and the hardships laid out or not. But if the applicant was not to receive a favorable by the rest of the board, was not able to receive a favorable decision, would they be able to put the architecture work and then come back for a separate variance with the setback.
There's a whole wide array of things.
Okay, I just want to make sure that that's
including
still
an appeal of
possible.
whether or not it's an architectural feature.
I'm wondering if that's still
Right.
possible for them to come back with
But
those.
why don't we concentrate on the variance we have in front of us?
Understood.
And I got to tell you, this board's new chair must be horrible because the old chair never had a problem getting a motion. I don't know what was
We're
happening.
still in discussion. You allowed discussion.
What? Any more board discussion? Otherwise, I will entertain
I
a
want to
motion.
say something. I want to say something. But
Sure.
Tina, if you want to say something, you can go first.
She's muted. Go on,
she's
Gary.
gonna say something. All right. Well, since we're actually discussing, I wanted to discuss the actual motion. But one, I thought Chad did have a good point because I think it's relevant to how we vote to know, do they have other avenues? So I thought it was a good question on his part. But in terms of discussing this one, I gotta say, I agree that it would have been really, really helpful to have video and schematics from, showing what it looks like when you're standing. Like, have someone stand at the utility box and have someone stand on the thing and show us that picture. I thought that would have been really helpful to the presentation. But at the end of the day, I thought that Mr. Dutzer made a lot of compelling points, and I do think that I don't know what AT&T is doing. They're working 3 hours at a time on a box. I think someone should investigate that. But, I do think that there are some unique aspects here when you got these two boxes right here that people are apparently like just hanging out at all day. He put $100,000 into the landscaping. It's an attractive feature. No one came forward to complain about it. I disagree with Mr. Abrams' point that the case has been made so compellingly that we have no discretion and we're bound to approve it. But I think he gets across 51%. I think, in this context, I think that, Mr. Dutzer's done enough right that he deserves to have this. He's improved. He's made an improvement. He's tried to make his backyard a bit more livable. He hasn't done anything terribly offensive. He used Gage, who is a well-respected architect, who thought he was well within the rules. So I'm inclined to vote for this.
And I've got to tell you personally, Mr. Dutzer, if the entertainment business doesn't go well for you, a side gig of public presentations could be in your future. Did a very good job for yourself. So the guy who normally makes the motions is making motions.
I hereby move that.
Wait, Gina had her hand up before you.
Go.
Wait, Blaze, go ahead.
Sorry, I was down for like 5 minutes. Is that an issue? Like, I literally lost connection.
Patrick's been here, or Mike's been here. 1, 2, 3, 4, 5, 6, 7. We've got 7. I would just say, and this is up to Dwayne, if he's been down for 5 minutes, does he sit out from voting?
No, it
There's been a lot of repetition. I don't think he missed anything.
Yeah, I think I got it.
Okay.
2 hours, I think I got it.
Okay. In that case, do I have a motion, Mr. Villeneuve?
I move that we find that the application meets the criteria for approval and that we approve it.
Second.
I've got a motion and a second. Bridget, did you get both the motion and the second?
Yes, I did.
Okay, can we, unless there are any proposed modifications to it, I'm going to ask Bridget to call the roll.
And I am ready. And Ms. Ellis.
Yes.
Mr. Villeneuve.
Yes.
Vice Chair McTeague.
No.
Mr. McGinley.
Yes.
Mr. Maxey.
No.
Mr. Reynolds.
No.
Mr. Chair.
Yes. Motion fails.
4-3.
Do we need a supermajority or is it a
Yes,
clear majority?
you need a supermajority.
Mr. Dutzer, a very good job. I think Mr. Abrams has got a lot of avenues to go from here that may get you where you want to go. Good luck to all of you.
Thank you.
Let's move on with our agenda. one item and Bridget's we're already putting you to sleep, Bridget?
I'm exhausted.
Got it. Communications to the commission.
I'm not going to make a motion for communication, but I thought Patrick raised a really good point that this is happening more and more with everyone's raising up the elevation of properties, and you're just going to see this issue more and more. And so I don't know that, I mean, I guess I could make a motion for communications.
I think you should, and if not, I'll ask Patrick to take the gavel, and I'll make a motion.
Patrick is in this business, so he could do a better job than I am. I think Patrick raised an important point. It needs addressing.
I think a sight line aspect to the height of the fence, I think that would result, not unlike rooftop equipment, where you know they don't specify the height.
Visual screening, right?
Okay, there you go.
The visual screening aspect of it. Bert, are you following where we're going from here?
Yes, I follow it.
So carry your motion to the commission would be to ask them to have staff look at amendments to the sign code so that concurrent with, fence code.
Yeah.
So that, thank you, Gina, concurrent with new higher building elevations from FEMA floodplain, there's actually a site screening aspect that could allow, under certain circumstances, higher fence heights to provide comparable screening to what was enjoyed under the 6'6" fence height, right?
Yeah. That's exactly, words out of my mouth. That's exactly the way I was going to word it.
I was reading your mind.
Would you accept an amendment?
What?
Yes.
To also include a clearer option for architectural features. To be right on top of the fence doesn't always make it appropriate. A lot of those lattices that you're speaking of, Howard, aren't on the fence. They're actually plastered right up behind them and come up behind them. So they're not actually on the fence. And I think there needs to be consideration for that if you're willing to accept that as an amendment.
Sure, yeah, and I think, you know, that's another way to accomplish the same goal, either raise the fence or allow a more flexible definition of architecture. They need to look at the whole thing, how they can accomplish the visual screening.
Yep.
Blaze, what does the puppy have to say about this? Wait, are you home now?
That's his back seat.
Yeah, really? That is a spacious car at the charging station, man.
We got the puppy at Wawa.
All right.
We need a second. Who seconded?
I'll second it.
Who is that?
Doug Reynolds seconds it.
Thank you.
All right.
I support it because I think it's a legislative issue. If you're going to change the elevation requirements, you've got to look at everything else. And that's why I think this matter brings us all to a head, and it needs to go to the city, and they need to really think about it, as you point out, in terms of the art. So I strongly think it's right on track.
So can we call the roll, Bridget, or do we just want to do it by acclamation? I don't think I see any. I think I see any votes. All in favor?
Aye.
Aye.
Any opposed? So show by unanimous vote.
Thank you.
Okay. Anything for the good of the city? Wear your mask.
Vote.
Okay. Oh, we do need to vote on the calendar. Sorry, guys. Anybody have a problem with the calendar that came out?
Pardon me, Chair, can you hear me?
Yes.
All right, so the code already sets out the dates that you actually need. This is just providing information.
Dwayne, give us an illusion of choice.
Okay, go ahead and vote.
At least the illusion of choice.
And Mr. Chair, my comment to vote was be sure to vote in the upcoming election.
Yes.
For anybody who hasn't voted yet, yes. And I'm from Chicago, so if you can vote twice, please do.
Yeah, all the better.
Our agenda does have a board vote on the calendar. So do we not need that, Mr. Spence? We can't change it. You're still muted.
I apologize. Yeah, you don't need that.
Okay.
Actually, when you change meeting dates, you would have to do so at the meeting before the meeting that you're going to change. So
Perfect. What you eating there, Blaze?
I moved to
All
adjourn.
right, in that case, motion to adjourn.
I just did it.
Perfect, we're done.
So moved.
Because under Robert's rules, you don't need a vote on a motion to adjourn. You just move it.
Done.
We're done.
Good night, everybody.
Bye.
Good night.
The recording has stopped.